My name is Mercy and I am from Group 14. Today it is our pleasure to present to you our answer on the comparison between English law and Malaysian law on the subject of undue influence. Here is the flow of our presentation today. Firstly, we'll start off with an introduction, which will be done by me. Next, we'll move on to similarities, and we'll also be doing an analysis on the similarities. And then we'll proceed on to differences together with an analysis, and lastly, we will end with a conclusion. Let's start off with the introduction. The law of contract has traditionally been concerned with pre-contractual fairness and places limits upon the exercise of economic powers by contracting parties. This is exemplified in the role of undue influence as one of the initiating factors that renders a contract voidable. Although the precise meaning of undue influence is not clearly defined, the objective of the law is clear that it aims to provide relief to the claimant who has suffered an impairment in his decision-making process, which is caused by his reliance on the defendant, and to discourage any abuse of a position of confidence by a contracting party through wrongful conduct. Now, in English law, undue influence is an equitable doctrine that applies in situations not covered by common law jurists, whereas in Malaysia, undue influence is expressly provided in Section 16 of the Contracts Act 1950. Now let's move on to similarities. These are the similarities that we will be covering in our presentation today. Now, it would be worthwhile first to present the generally accepted view that the Malaysian position on the law of undue influence is the same as that prevailing in England, despite the existence of an express provision in the Contracts Act. In the case of Tengku Abdullah Ibn Sultan of Negara, one of the judges, Justice Gopal Srirab, indicated that Section 16 does not differ from the English law on the subject of undue influence. He cited the case of Pusaturai as the basis of the aforementioned observation, where Lord Shaw asserted that there was no difference on the subject of undue influence between the Indian Contract Act and the English law. This statement is relevant to the landscape of Malaysian law because Section 16 of the Contracts Act is in pari materia with the identically numbered section of the Indian Contract Act. Now, however, it is important to note that in making such a statement, the learned judge actually did not make any reference to English cases. Now let's get into the specifics. How are they similar? This similarity is seen firstly in terms of the traditional approach of the courts to distinguish between actual undue influence and presumed undue influence. In English law, this classification was approved by the House of Lords in the case of Barclays Bank after years of being developed. Lord Brown Wilkinson affirmed the classification and effect of actual and presumed undue influence in the following categories. Class 1, actual undue influence, which requires the claimant to prove that the wrongdoer had exerted undue influence to induce his entry into the contract. And class 2, presumed undue influence, which arises out of the relationship of trust and confidence between the contracting parties. Although this distinction is not expressly provided in Section 16 of the Contracts Act in Malaysia, the Malaysian courts have adopted the same categorization. In the case of polygram records, the court endorsed Lord Brown Wilkinson's classification of actual and presumed undue influence and cited it directly to decide the case, though with an additional element of manifest disadvantage, which will be discussed by my friends later. Now, here are some other Malaysian cases where the courts have expressly used the terms and principles of actual and presumed undue influence. In addition to the Malaysian court's direct adoption of the principles of English common law on undue influence, the traditional categories of actual and presumed undue influence are also seen in the provisions of Section 16. The courts have applied Section 16 sub 1 for cases of actual undue influence and Section 16 sub 2 for cases of presumed undue influence. In the case of RHB Bank Berhad and Single Fire, the court indicated that actual undue influence had to be proved under Section 16 sub 1 of the Contracts Act. The three constituents had to be satisfied, namely that one of the parties were in a position to dominate the will of the other party, that party had used that position to influence the other party, and an unfair advantage had been obtained as a result. The provision of Section 16 sub 2 is analogous to the English law of presumed undue influence because it presupposes a relationship, either a fiduciary one or one where the party holds a real or apparent authority over the other. Once this is proven, the presumption of influence arises. Similarly, in English law, the court held in the case of Alcard and Skinner that the presumed undue influence arose where the relations between the contracting parties raised a presumption of influence over another. The courts further elaborated on this class of undue influence in Royal Bank of Scotland and Ipswich and established a test for the two names under Class 2A presumed undue influence. Now that is all for my part on similarities. Let's move on to my friend Rong En, who would further discuss the similarities between English law and Malaysian law on undue influence.
Now that Mercy has illustrated how Section 16, subsection 1 and 2 of Contracts Act 1950 commensurates with English law, and I will now move on to the other similarities. English and Malaysian law take a similar stance when it comes to the shift of burden of proof. Section 16, subsection 3a, together with illustration C, is analogous to the English law rule. To contextualize, the legal burden of proving undue influence always rests on the person alleging it. The evidence required to discharge the burden of proof depends on the nature of the alleged undue influence and the surrounding circumstances of the case. Under both jurisdictions, if the claimant successfully raises a rebuttable presumption of undue influence or enables an inference of undue influence to be drawn, the claimant could discharge the legal burden. The burden then shifts to the influencer to produce evidence to counter the interference to prove otherwise, which is, to show that the agreement was not induced by undue influence. This shift is necessary because by reposing confidence in the influencer, the claimant endows the influencer exceptional authority over himself and would expect the influencer to give unbiased advice. It is, however, highly possible that the influencer will prioritize his own interests over the dominated party. Thus, the burden lies on the former to prove otherwise and that he has not abused his position. Moving on, the onus is now on the influencer to rebut the presumption. English and Malaysian law adopt comparable positions on this issue, and examples are provided in the table. Essentially, the party accused of exercising undue influence may rebut the presumption by proving that the vulnerable party exercised his free will in entering the transaction. This is most commonly established by demonstrating that the claimant sought independent legal advice and was fully aware of the nature as well as risks involved before signing the alleged document. However, this is not conclusive, and weight to be given to that advice depends on the overall circumstances of that case. Though it does not necessarily rebut the presumption, it is nevertheless a strong argument, which is evidenced by both Royal Bank's case under English law and Inche Noria's case under Malaysian law. Furthermore, the effect of and relief for agreements induced by undue influence are similar in English and Malaysian law. To summarize, an agreement induced by undue influence is voidable at the option of the innocent party. If rescission is ordered, the whole transaction would be set aside as if no contract was entered into. In this respect, the agreement would be annulled retrospectively from the date on which it was made. Courts will restore parties to their original positions as bare as the law can do in the circumstances, subject to the same 4 bars of rescission. Chris and Thomas illustrates how practical justice is served. In this case, property prices had slumped when rescission was ordered, so the proceeds of sale that the plaintiff got was much lower than what he had paid. This is, however, the best the law can do in this situation. In Malaysian law, this is governed under Section 20 of the Contracts Act. Section 65, 66, and 73 will come into picture when a voidable contract is rescinded. Done comparing, I will now conclude my part with an analysis of the similarities. In UK, the principles of undue influence are covered by common law, whereas Malaysian law is governed by Contracts Act 1950. It is pertinent to note that Contracts Act is more broadly defined to cover English law, and the most obvious example would be subsection 1, where its broad meaning is potentially able to cover a broad spectrum of unconscionable transactions. In the current context, is similarities desirable? In fact, it would be helpful to apply a common notion to different factual situations using a comprehensive conceptual definition of that notion. Moreover, this would predicate Malaysian contract law on a well-founded groundwork laid down by the more seasoned English courts. As a result, the parameters and the doctrinal basis of undue influence becomes more certain and consistent. Justice of Court of Appeal Gopal Srirang propounded in the case of Tengku Abdullah that decisions of the English courts are a useful guide to the approach that our courts should adopt when interpreting Section 16. However, we must ultimately have regard to the wording of our own statute. Hence, deciding a Malaysian matter solely on the basis of English judgment would be completely untenable. The more recent decisions of the English courts also reveal that their concept of the doctrine and the relationships to which it might be applied to do not correspond with the moral standards of Malaysia's culture. This is especially evident in non-marital cohabitee relationships. On grounds of public policy, Malaysian courts will not extend this doctrine to those non-marital relationships. It would thus be incorrect to blindly accept all foreign judgments if the outcomes might foster moral decadence within our own social framework. From this, we can see that English and Malaysian law share a number of similarities regarding the doctrine of undue influence. It is undeniable that English decisions serve as a useful guide but Malaysian courts should ultimately have regard to our very own Section 16 of Contracts Act 1950, and this section, being a remedial provision, should be interpreted in a broad and liberal fashion. That's all from me. I will now pass on to my other group mates to discuss about the differences. Thank you very much.
Now we are going to look at the differences between English law and Malaysian law. The first difference is the domination of the will. In Malaysian law, Section 16 Contracts Act 1950 mentions that the domination of will is required to establish the undue influence. It also states that the presumption of dominant party. In Legunat and Prezat and Sarju Prezat, the court held that the lender was not in the position to dominate the will of the borrower. Although the other elements were fulfilled, the claim was dismissed, distinguishing this case with Caution Board and others and Caution Pool and others. Since the solicitor was a fiduciary to his client, there was the presumption of the domination of the will. When other elements are fulfilled, then the claim was successfully entitled. So, we can conclude that the domination of will is important for the plaintiff to prove the undue influence in Malaysian law whenever under actual undue influence or presumed undue influence. Going to English law, in Tufton and Spurney, Court of Appeal consistently stated that the domination of the will was unnecessary in trust and confidence. Court of Appeal decision in Tufton case was agreed by Lord Justice North in Parkes Bank case and comment by stating there was no requirement for English law to show that the parties in the trust and confidence must be in a position to dominate the will of the other party. Therefore, one can deduce that the domination of will is unnecessary in Class 2B of presumed undue influence. Then we are going to Godsworthy and Bricker. Lord Justice North brought the statement with a bigger view. He mentioned that the domination of the will had never been a requirement for raising the presumption of undue influence by removing Ted and Williams and Oka and Skinner. In these cases, the requirements to establish presumed undue influence are a presumption of undue influence and fails to rebut the presumption during calls for an explanation by the dominant party. So, it covers the domination of will is unnecessary in Class 2A and Class 2B. Looking at the analysis part, one may be confused that the domination of will has never been declared in English law under the presumed undue influence. Why is there discussion about it? Below is the analysis of Lord Justice Parker in Godsworthy and Bricker. The first reason is that in English law, the presumption of undue influence can only apply to a relationship in which one party assumes a law of dominating influence over the other. So they may have people confused about the difference between the assumption of dominating the will and the actual domination. The second reason is that Lord Scarman in National Westminster Bank case and Morgan cited the word domination from Pusaturai and Kanapa Chetia. As we know that Pusaturai case is an Indian case, the case is decided according to Section 16 Indian Contract Act 1972. The court may be confused whether the actual domination of the will is required in further cases. After knowing the background, we should know that the reason of domination of will is rejected in English law. Firstly, there is a difference between the assumption of dominating the will and the actual domination. The former is likely to be not substantive and rely on the presumption of influence, while the latter is the actual and express domination by the dominant party, and it needs to be proved by the claimant where Section 16, Subsection 2, Contracts Act 1950 does not work. Secondly, after analyzing the Morgan case, Lord Justice Parker said that although Lord Scarman cited the word domination in Morgan case, he found that the domination of the will was not part of Morgan approach. Thirdly, domination of will seems so redundant because if it is required, the plaintiff needs to prove it. In English law, the cause for an explanation actually gives the opportunity for the defendant to rebut the presumption of undue influence, so it is too redundant to do it. On the contrary, in Malaysian law, since Malaysia practices a written constitution, so one needs to focus on the statutes. Section 16 Contracts Act 1950 states the domination of the will in the presumption of the dominant party. So, Malaysian courts are more willing to interpret the literal meaning of the statutes. In conclusion, the domination of the will is essential in Malaysian law, but not in English law, which is under presumed undue influence.
Thank you, Kerchi. Now we are moving on the second difference, manifest disadvantage. Section 16, subsection 1 of the Contracts Act requires the claimant to show that the dominator of his will must use his position to obtain unfair disadvantage over him. This is absolutely different from English law. However, as the judge of Court of Appeal Gopal Sriram stated that we should give priorities to the words in our own statutes, The requirement of proof of unfair disadvantage is therefore crucial in Malaysia to prove that the claimant is unduly influenced, regardless of actual or presumed, to enter into a contract and to make the contract voidable at the option of the claimant under Section 20. Therefore, for instance, the claim raised in Ibrahim bin Musa and Bahari bin Nayan was dismissed on the grounds of the claim failed to prove that the defendant had used his position to obtain an unfair disadvantage over her. The court also stated that even the position of the domination of the will was proven, the claim would still fail on the same ground as all the requirements are indispensable. On the other hand, the development of English common law has abandoned manifest disadvantage as a requirement in undue influence cases. Initially, select law justice in Black Bank of Credit and Commerce International SA and Abudi held that the complainant must prove the transaction to be manifestly disadvantageous in both actual and presumed undue influence. However, this had been overruled by the court in CIBC Mortgages Private Limited and Pitt, where Lord Brown Wilkinson concluded that the Court of Appeal in Abudi had erred in requiring manifest disadvantage to be shown in both types of undue influence. Any substantive unfairness to the claimant is not a necessary requirement in cases of actual undue influence. Rationales provided that was that actual undue influence is a species of fraud, and like any other victim of fraud, a person who has been induced by undue influence to carry out the transaction which he did not freely and knowingly enter is entitled to have the transaction set aside as of right without proving manifest disadvantage. So, in English law, actual undue influence cases do not require manifest disadvantage to be proven, unlike in Malaysian law. There was a continuous argument on whether the requirement of manifest disadvantage should be used to prove presumed undue influence. Initially, there was a requirement of manifest disadvantage in the case of presumed undue influence in English law. However, it was replaced by another test, which is the transaction calls for explanation. The later part will be discussed by my friend Yuan. The House of Lords in National Westminster Private Limited and Morgan reversed the Court of Appeal decision, and Lord Scarman explained that the Court of Appeal was wrongful in holding that the presumption of undue influence can arise from the evidence from the relationship of the parties, without also evidence that the transaction was wrongful in that it constitutes an advantage taken of the person subjected to the influence which, failing proof of the contrary, was explicable only on the basis that the undue influence had been exercised to procure it. Lord Brown Wilkinson in Pitt implied that manifest disadvantage should not continue to be a necessary element in Class 2 actions due to its limitation. The limitations will be discussed by Yuan later. However, a journal article written by Catherine Culligan further explained that the courts were reluctant to abandon the requirement of manifest disadvantage in presumed undue influence cases because without this requirement, the presumption would normally be raised solely upon proof of special relationship of influence, and it is difficult to rebut the presumption, and the defendant would be more likely to be held liable, and therefore, transaction would be more likely to be overturned. It will provide a disincentive for many business people, including lawyers or bankers, to enter into transactions with parties that could be regarded as weak or reliant on the advice of the former. As so, many relationships involve a degree of influence, commerce could arguably be undermined. I will pass on to Yuan to explain on the second part.
As explained earlier, the judgment in Pitt set out that manifest disadvantage is only required in cases of presumed undue influence and not actual undue influence. Nonetheless, the landmark case of Royal Bank of Scotland and Eatridge seems to have thrown the law into a state of disarray, with the judges unable to reach a consensus on this matter. Lord Nichols posits that the test for manifest disadvantage should be discarded and replaced with the search of something more which calls for an explanation, which was first outlined in the case of Allcard and Skinner. Lord Hobhouse did not treat the element with such disdain and instead argued that the relevance of manifest disadvantage is evidential. Perhaps more interestingly, Lord Scott described manifest disadvantage as merely a description of a transaction which cannot be explained by reference to ordinary motives by which people are accustomed to act. The case of Eatridge may have been an illuminating judgment for the law of undue influence as a whole, But these differing opinions prove that it may have further confounded the law with regards to the requirement of manifest disadvantage. As Jing Kwan mentioned, some academics opine that the element of manifest disadvantage is a non-negotiable one, because otherwise the presumption of undue influence would be too easily raised. This has many undesirable consequences, especially in the world of commerce. On the other hand, dissidents of the manifest disadvantage test concede that it is not completely irrelevant per se. It merely indicates the extent of any presumption of undue influence and any subsequent burden of rebutting such a presumption. Nonetheless, they continue to argue that the manifest disadvantage test is dissatisfactory because the threshold is far too low. This is because it is one that is met in absence of any direct benefit, or in cases of surety agreements if there is a potential burden of a guarantee. Accordingly, the test would be satisfied in nearly all instances. With all due respect, there is no reason or benefit to the English courts to continue with this strife over which is the better approach. Professor Chen Wishart has advanced a compelling argument that the issue of misinterpreting labels, which was first raised by Lord Nichols in the case of Eatridge, can similarly apply to his preferred test or something more as well. Courts may still run the risk of denying relief to an aggrieved party simply because the transaction is perfectly explicable on grounds of their loyalty or commitment to the alleged influencer. For instance, she argued that in Olcott there was nothing inexplicable about a nun's decision to offer her worldly possessions to the service of God. No test is ever free from its own shortcomings. The judges in Eatridge did nothing to clarify this particularly contentious area of the law, if they haven't already contributed to the mess that this area of law has gotten itself into. But if we may add on, the tests of manifest disadvantage and something more are both just means to an end. Ultimately, we should turn to the originator of the manifest disadvantage test, Lord Scarman. In the case of Morgan, he equated manifest disadvantage to hard and inequitable agreements or immoderate and irrational transactions, among others. Perhaps it was Lord Scott who captured the gist of Lord Scarman's judgment most accurately, that the presence of manifest disadvantage is already pointing towards something more which calls for an explanation. Once we understand that both concepts are undoubtedly intertwined, then this whole debate on which approach is the correct approach becomes redundant, and the truth in McKendrick's statement that this is a change of label rather than substance becomes profound. To that effect, even if the English courts were to insist on the disposal of the manifest disadvantage test, the English approach might not radically differ from the Malaysian approach after all. If a transaction has, lending the words of our Contracts Act, an unfair advantage, or is unconscionable, it is still not difficult to reconcile this with the notion that this is something which calls for an explanation. At first instance, the English and Malaysian approaches towards undue influence may appear to be in stark contrast, especially when we refer strictly to the wording of the Malaysian Contracts Act. However, a step back to take a look at the bigger picture will reveal that perhaps there is more in common between the two than we may initially believe. Much of the English principles, such as the categorization into actual and presumed undue influence, the need for rebuttal of presumption, the subsequent shift in burden of proof, and the remedies for contracts vitiated by undue influence, among others, can easily be found in our Malaysian courts. Even some of the differences that we've discussed, such as the requirement of manifest disadvantage, are arguably confined to semantics, and its practical effect on the outcome is highly debatable. Ultimately, the starting point in Malaysia will always be the Malaysian Contracts Act, and perhaps codification in our law has occasionally saved us the trouble of judicial disagreements over certain final points of the law, as we have seen in English courts. Nonetheless, our courts haven't exactly been averse to following the lead of English common law, with our Malaysian judges often seeking guidance from decided English cases whenever in doubt. Until and unless there is radical reform in our judicial behavior, it is highly likely that the English common law will continue to steer the development of our Malaysian law pertaining to issues of undue influence, with the influence of the former inextricable from the latter. With that, I'd like to end our presentation. Thank you.